out of public demand that students are requesting for me to discuss on criminal litigation and the mistakes that you should avoid when drafting a criminal charge and charge sheet in Kenya. This is a lesson that is emanating from the fact that CLE in all its papers have asked a student to draft a charge or a charge sheet in one way or another. So this is informed now the basis of this session. So 90% of criminal litigation papers have a charge sheet. So mistake number one is failing to disclose an offense known in law. So you should not draft particulars that do not amount to the offense being charged, because a charge must contain a specific offense and particulars sufficient to inform the accused of the nature of the offense. This is pursuant to section 134 of the Criminal Procedure Code. So, for you to see the practicability of it, I'm telling you how to avoid such. Avoid the accused fail to comply with lawful orders statements. Without stating that lawful order, who issued it, under what authority, and how non-compliance constitutes the offense. So stop generalizing an offense. So that is mistake number one that students usually do. They fail to disclose an offense known in law by being general. Mistake number two is citing the wrong statutory provision. Always confirm the exact section creating the offense and, where necessary, the penalty section. For some offenses, the section creating the offense and the section prescribing the punishment are different, and charging only under the penalty section can make the charge defective. Do you know that you will be allowed to enter into the examination room with a penal code to avoid these mistakes? The example of mistake that you can do is to say defilement contrary to section 8.3 of the Sexual Offences Act without citing section 8.1, which creates the offense. So Kenyan courts have quashed convictions where the charge cited a non-existent section or only a penalty provision, especially in sexual offense matters. So be keen, because we saw in April 2026 paper question 1, mandatory question, where students were also told to draft a charge, and the charge was particularly confined to Sexual Offences Act. So this now confirms that many students never drafted section 8.1, which creates the offense. Mistake number 3 is to omit essential ingredients of the offense. Every essential legal element must appear either in the statement of offense or particulars. For example, for robbery with violence, particulars should show the relevant aggravating factor, such as being armed with a dangerous or offensive weapon, being in company, or using or threatening violence. So avoid generic particulars that do not include the ingredients required by the statute. Mistake number 4 that you will do is to draft vague particulars. And particulars should normally state the date or approximate date, the place of the offense, name of the complainant and victim if known, property involved if any, value of the property where relevant, act or omission alleged, and lawful intent where required, special facts such as age, lack of consent, use of weapon, public office, license status, quantity, identity, document, etc. So it is a bad example to state on diverse dates in Nairobi the accused stole money. Very wrong. Better to say, on the 10th day of March 2026 at Westlands in Nairobi County, the accused stole 250,000 Kenya shillings, the property of ABC Limited. Mistake number 5 is to be unnecessary wordy or pleading evidence. A charge is not a witness statement. Do not include the whole evidence, background story, investigative conclusion, or legal submissions. State only the material facts or particulars needed to inform the accused of the offense. Mistake number 6 that you'll do is on duplicity. This is where you'll go ahead to charge 2 offenses in one count. Very fatal. Each count should contain one offense only. Do not combine separate offenses in one count. Avoid stealing and obtaining money by false pretenses contrary to section this and this. If the facts support separate offenses, draft separate counts or proper alternative counts. Mistake number 7 that you'll do, improper joinder of counts. Under section 135 Criminal Procedure Code, Offenses may be joined where they are founded on the same facts or form part of a series of similar transactions, but improper joinder may embarrass the defense or lead to separate trials, so avoid joining unrelated offenses merely for convenience. The same also applies for improper joinder of accused persons. Where several accused persons are charged together, ensure their joinder is legally justified. For example, same offense, same transaction, common purpose, conspiracy, aiding and abetting, or connected conduct. Do not charge persons jointly where the facts against each are separate and unrelated. So this was tested in the April 2026 paper question 1, where it was a joinder of accused persons in regards to the same offense, same transaction, and common purpose. So mistake number 9 is to use the wrong complainant or owner of property. In property offenses, identify the property owner correctly. If property belongs to a company, estate, government agency, or employer or institution, state that clearly. Avoid naming an employee as owner where the property belongs to the company unless the law allows possession or special property to be pleaded. Failing to state value, quantity, or description are relevant. Wrong or inconsistent dates. Wrong place or court jurisdiction. Omitting age in sexual or child offenses. Remember, for sexual offenses involving children, age is often central to the offense and sentence. So state the complainant's age clearly. Intention, example, intentionally and unlawfully caused his penis to penetrate the vagina of this PWM, a child age 12 years. Also ensure the cited subsection corresponds to the child's age bracket. The other mistake you'll do is to charge the wrong offense instead of an attempt, conspiracy, aiding, or abetting, or even handling. So match the facts the correct offense. If the act was incomplete, consider attempt. If the accused assisted, consider aiding and abetting. If the accused has received stolen property after theft, consider handling or related offenses. Do not force facts into a mere serious offense where the ingredients are not present. 15. Failing to use alternative counts properly. Where the evidence support either of two offenses but not both simultaneously, use alternative counts correctly. Example, count 1 you can say stealing, alternative count can be handling stolen goods. Avoid making alternative counts look like independent cumulative charges. Mistake number 16 is to use and/or carelessly. And/or can create ambiguity. Be precise. Criminal charges should be clear because the accused must know exactly what case to answer. 17. Failing to distinguish the statement of offense from particulars. A proper count should have a statement of offense that reads stealing contrary to section 268 as read with section 275 of the Penal Code. Particulars should be different from statement of offense. On the 10th day of March 2026 at Westlands in Nairobi County, the accused stole one Samsung mobile phone valued at 45,000 Kenyan shillings, the property of one Jane Wanjiku. Do not merge everything into one confused paragraphs. Another mistake is to charge under repealed, non-existent or amended provisions. Another mistake is to fail to amend a defective charge in time. If the evidence or law shows the charge is defective, apply to amend under section 214 of the Criminal Procedure Code before it is too late. When a charge is altered, the accused must be called upon to plead to the altered charge and may demand a recall of witnesses. In section 20, not section 20, mistake number 20 is to assume every defect will be cured by section 382 of the CPC. Section 382 of the CPC may cure some errors if no failure of justice is occasioned, but serious defects such as failure to disclose an offense, omission of essential ingredients, or to misleading the accused may invalidate the conviction. Do not rely on the court to cure pure drafting. So, quick drafting checklist before you do any question to do with relation to charge sheets is this: confirm the correct accused names and aliases, correct offense title, correct statutory provision creating the offense, correct penalty section, all ingredients of the offense, date or period, place, complainant, property, value. Each count contains only one offense, joinder of counts, accused is proper, alternative counts are clearly marked, charge matches available evidence, no repealed or non-existent section is cited, particulars are clear enough for the accused to prepare a defense. Main authority is that Section 134 of the CPC requires every charge to state the specific offense and provide necessary particulars, giving reasonable information on the nature of the offense being charged. So, meaning of the mistake: this mistake occurs where the prosecutor drafts a charge for the completed main offense, yet the facts only support a different form of liability, such as attempt. This is where the accused tried to commit the offense but need not complete it. 2. Conspiracy. The accused agreed with another person to commit an offense, but the offense may not yet have been committed. 3. Aiding or abetting. The accused assisted, encouraged, facilitated, counseled, or procured another person to commit the offense. Handling stolen goods. The accused received, retained, disposed of, or assisted in dealing with stolen goods, stolen property after it had been stolen, but may not have participated in the actual stealing. So this is where I take a deeper dive on exactly showing you how you will confuse with illustrations and better charges to insert etc. So it is a very practical point of it. So charging, for instance, the first mistake that you will do is to charge theft where the facts only show an attempt to steal. This is very important. So illustration, you have been told that a person enters a supermarket, hides items under his jacket, but is stopped by security before leaving the premises. The items are recovered before he exits. So the wrong charge will be stealing contrary to section 268 as read with section 275 of the Penal Code. Why it may be wrong? For stealing, the prosecution must prove that the accused fraudulently and without claim of right took something capable of being stolen with the necessary intention to permanently deprive the owner. So if the evidence shows that the accused was stopped before completing the act of taking, the safer charge may be attempted stealing depending on the facts. So the better charge will read as follows: attempted stealing contrary to section 389 of the Penal Code as read with sections 268 and 275 of the Penal Code. So there is attempted stealing because he was caught contrary to section 389 of the Penal Code as read with section 268 and 275 of the Penal Code. So the drafting point is that do not charge the completed offense simply because the accused intended to commit it. If the act was interrupted before completion, consider it as an attempt. Charging robbery with violence where facts only show attempted robbery. Illustration: 3 men armed with knives confront a motorist and demand money. Before they take anything, police arrive and arrest them. Wrong charge is to charge robbery with violence contrary to section 296(2) of the Penal Code. Problem: robbery involves stealing, accompanied by or followed by evidence or threat of violence. If nothing was actually stolen, the completed robbery may not be proved. Better charge is to say attempted robbery with violence contrary to section 297(2) of the Penal Code. The drafting point is that if violence or threats occurred but no property was taken, attempted robbery may be more appropriate than robbery. Point number 3, charging obtaining by false pretense where no property or money was actually obtained. Illustration is that an accused person falsely tells a complainant that he can sell him land. The complainant discovers the lie before paying any money. Wrong charge is to charge him for obtaining money by false pretenses contrary to section 313 of the Penal Code. Why is it wrong? The offense of obtaining by false pretense requires proof that the accused actually obtained something by means of the false pretense. If no money, goods, or benefit was obtained, the completed offense is not proved. So the better charge will be, depending on the facts, attempting to obtain money by false pretense contrary to section 389 as read with section 313 of the Penal Code. And the drafting point will be where the accused made false representation but the complainant did not part with money or property, consider attempt. 4. Charging stealing where the accused only received stolen property later. An illustration is a phone is stolen from a complainant in Nairobi CBD. 2 days later, the accused is found selling the phone. There is no evidence that he participated in the original theft. So wrong charge is to charge him with stealing contrary to section 268 as read with section 275 of the Penal Code. And why it may be wrong is that to prove stealing, the prosecution must connect the accused to the actual taking of the property. Mere possession of recently stolen property may sometimes support an inference of theft, but where the evidence shows later possession, receipt, or sale, the more appropriate charge may be handling stolen goods. So the better charge will read as handling stolen goods contrary to section 322 of the Penal Code, and the possible particulars will be on the 15th day of June 2026 at Nairobi CBD within Nairobi County, otherwise than in the course of stealing, dishonestly retained or assisted in the disposal of one Samsung mobile phone valued at Kenya shillings 45,000, knowing or having reason to believe it to be stolen property. So the drafting point is that handling is appropriate where the accused role begins after the theft. Point number 5 is charging handling where evidence shows participation in the original theft. So illustration will be a shop attendant helps another person remove goods from the employer's store at night, and the goods are later found in the attendant's house. So the wrong charge is to charge him for handling stolen goods contrary to section 322 of the Penal Code. And why it may be wrong is because handling usually applies where the accused deals with stolen property otherwise than in the cause of stealing. So if the accused participated in the actual taking, the proper charge may be stealing or stealing by servant depending on the facts. So the better charge will read stealing contrary to section 268 as read with section 275 of the Penal Code, or if the accused is an employee and the property belonged to the employer, stealing by servant contrary to section 281 of the Penal Code. So the drafting point is that do not use handling where the accused is alleged to be one of the actual thieves. Step number 6, charging the main offender where the accused merely assisted. Illustration is that a person keeps watch outside a shop while another person breaks in and steals goods. So the wrong approach is to charge the lookout as if he personally broke into the shop and physically stole the goods without pleading or proving his participation. Better approach is, depending on the evidence, he may be charged as a principal offender if he aided or abetted the commission of the offense. So under the Penal Code, persons who actually commit the offense do an act to enable or aid another to commit it, aid or abet another, or cancel or procure another may be treated as principal offender. So the possible charge is breaking into a building and committing a felony jointly with another contrary to the relevant provisions of the Penal Code, and the particulars should show his role. For example, the accused jointly with another, not before court, broke and entered the shop of ABC Traders and stole assorted goods valued at 200,000 shillings. If the accused did not personally perform the physical act but assisted or encouraged it, ensure the charge and evidence support liability as an aider, abetter, counselor, procurer, or joint offender. Point number 7 is charging, aiding, and abetting where the facts show conspiracy. Very technical here. Illustration. 3 people meet and agree to rob an M-Pesa shop the following day. They are arrested before buying weapons, going to the shop, or confronting the complainant. The wrong charge is to charge robbery with violence contrary to 296(2) of the Penal Code. Why is it wrong? No robbery occurred, no property was stolen. There may also be insufficient acts to prove attempted robbery. So the better charge will, depending on the evidence, conspiracy to commit a felony contrary to the Penal Code. The drafting point is that conspiracy focuses on the agreement to commit an offense. Attempt focuses on acts done towards committing the offense. So the two are not and will never be the same. Conspiracy, the agreement to commit. Attempt, acts done towards committing. Point number 8. Charging conspiracy where the evidence only shows preparation by one person. Illustration. An accused person is found alone with a fake number plate and gloves. There is no evidence of an agreement with anyone else. So the wrong charge is to charge conspiracy to commit robbery. Why is it wrong? Conspiracy requires an agreement between 2 or more persons. A person cannot conspire alone. Better charges, depending on the facts, consider preparation to commit a felony, possession of suspected stolen property, possession of housebreaking implements, attempted offense if facts had gone beyond preparation, or no charge if the evidence is insufficient. So do not charge conspiracy unless there is evidence of agreement. 9. Charging attempted offense where the facts show mere preparation. Illustration: a person buys a crowbar and is found near a shop at night, but there is no evidence that he tried to break the door, enter the premises, or confront anyone. So the possible wrong charge will do is to charge attempted or breaking into a building and committing a felony. Why it may be wrong is that an attempt requires conduct that goes beyond mere preparation. The accused must have done an act sufficiently connected to the commission of the offense. Buying tools or being nearby may be suspicious but may not necessarily amount to an attempt. So the better approach is to consider whether the facts support another offense, such as possession of housebreaking implements, preparation to commit a felony, or other specific statutory offense. So do not confuse preparation with attempt. Point number 10. Charging the wrong sexual offense instead of an attempted sexual offense. Illustration is that an accused person attacks a child and tries to undress her, but there is no evidence of penetration. The wrong charge is defilement contrary to Section 8 of the Sexual Offences Act. Why it is wrong? It is because defilement requires proof of penetration. If penetration is not proved, the completed offense may fail. So the better charge, depending on the facts, it is attempted defilement contrary to Section 9 of the Sexual Offences Act, or possibly committing an indecent act with a child contrary to Section 11 of the Sexual Offences Act. So the drafting point is that in sexual offences, distinguish carefully between penetration, attempted penetration, and indecent act. Point number 11. Charging murder where the facts show aiding after the fact. Illustration: a person does not participate in a killing but later hides the weapon or helps the suspect escape. So the wrong charge will be murder. Why it may be wrong is that murder requires proof that the accused with malice aforethought caused the death of the deceased, either personally or through participation recognized by law. If the accused only assisted after the killing, he may not be guilty of murder unless there is evidence of prior agreement, common intention, aiding before or during the offense, or participation in the killing. In the Okothobado, the former governor, Okothobado case, there is the application of common intention doctrine. Okay, so if there is evidence of prior agreement, common intention, aiding before, during the offense, or participation in the killing, then you can charge murder. You can charge for murder. But the better charge if those elements miss. Depending on the facts, consider offenses such as accessory after the fact, obstructing justice or police duties, harboring an offender, other relevant penal code offenses, and the drafting point in this situation will be assistance after the offense is different from aiding and abetting before or during the offense. So charging the wrong offense can lead to acquittal because the ingredients are not proved. Amendment of the charge under Section 214 of the Criminal Procedure Code, delay in trial, prejudice to the accused, rejection of a plea of guilty if the facts do not support the charge, and conviction being quashed on appeal. So before settling on a charge, ask yourself the following: was the offense completed? If not, did the accused go beyond preparation? 3. Was there an agreement with others? 4. Did the accused help before, during, or after the offense? 5. Did the accused personally take the property or only received it later? 6. Do the particulars disclose every ingredient of the selected offense? Now, in the next session, we will discuss on various sample charge sheet drafts for offenses that are commonly confused, where we now test the completed offense, attempt, conspiracy, aiding, abetting, handling, and accessory after the fact. Now, this is where I'll be distinguishing between stealing versus attempted stealing, where it is complete. I look at the particulars, etc., so that we have now a practical overview of what we were discussing. So keep that as the second session, where we will have to go beyond the normal requirements of knowing one offense, but we will be knowing an offense vis-a-vis an attempt of it and conspiracy, etc. So basically, as a key takeaway, I want you to take this part as your takeaway. Before settling on any charge, always ask yourself those questions. Thank you so much. Let us meet in the second session.